Hi, it's Wendy Hernandez with Command the Courtroom. In today's video, I'm going to talk with you a little bit about how you can keep the judge from getting really angry at you or keep the judge on your side if the judge is already on your side. And the main thing that you can do to not make the judge mad at you or keep the judge on your side is be reasonable in what it is that you're asking for. And I know that sometimes it's pretty hard to figure out what's reasonable because this is your case, this is your life, these are your children, it's your future. And you want what you want and you're really biased. It's hard to see the other side. It's hard to see the other side as being reasonable. But to the best of your ability, when you're going through a case, when it comes to whatever request that you're making or whatever position you're taking, I think that you should always put yourself in the position of the judge and ask yourself, what would WWJD, what would judge do? What would the judge do? Because ultimately, if you're going to trial, your judge is going to be the one making the decision. The judge ultimately is the most important person in your case because that person is the one who has the final say over what's going to happen. The reason I thought this would be a good topic to address in today's video is because I recently had a couple of different cases where a judge thought that my client's positions were unreasonable. And in one case, my client didn't see where his position was unreasonable, and the judge actually punished him pretty severely in her final ruling. And in the other case, in the midst of gaining the understanding that the judge thought he was being unreasonable, my client got it, and he switched his position, and we were able to salvage things to a certain extent. So let me give you these couple of different examples. In one case, we had a temporary orders hearing, and it was like in November of 2015. And as a result of the temporary orders hearing, our judge ordered my client to be responsible for paying the car payment on the family vehicle as well as the car insurance on the family vehicle until the time the final hearing came around. So what happened was, as we were waiting for the final hearing, the car tags came due on the family vehicle. And my client wanted his soon to be ex-wife to pay half the tags. She didn't have a job, she wasn't working, she didn't have full-time access to a vehicle because they were sharing one vehicle and he worked full-time. So she wasn't able to pay for the tags. She never responded to my client's request that she pay for half the tags. So ultimately my client decided not to pay for the tags, even though he had been ordered to pay for all other expenses related to that vehicle. Well, the judge got really upset with him at the final trial because he didn't pay for the registration on that car, and he was the one that was earning the money and he had the means to do so. And she punished him, and this the fact that he didn't pay for the tags came up at least actually a total of 3 times in the final minute entry. And the judge really let my client have it in other areas, and there's other things that my client did that I think the judge did not like. But the tags were a big thing in this case. She brought it up over and over and over again that he was unreasonable. His conduct of not just simply paying for the tags was unreasonable. By the way, she also said that the wife's conduct of not responding to my client's request to pay the tags was also unreasonable. So that's one example of how things can go really bad if in the judge's eyes you're being unreasonable. The worst part in that case was, however, that my client has been ordered to pay a portion of the now ex-wife's attorney's fees and costs, and that is due in part to my client's or the judge's perception of my client's unreasonableness. So let me tell you about the other situation that went down a couple weeks later. My client went in front of a new judge. She's probably been on the bench a couple of months, and my client was asking for sole decision making of the party's children. He had been ordered sole decision making of the children on a temporary basis. A prior judge on the case had found that there was substantial domestic violence perpetrated by the wife against my client. There was evidence of mental health issues, mother neglecting the children. There was a whole host of issues that led my client to ask for sole decision making, which is also known as custody. Well, when we got to trial on the day of trial, the judge, who was newer, said that she felt our request for sole decision-making authority was unreasonable. And in the courtroom, I tried to explain to the judge multiple times all the reasoning behind that request for sole decision-making, and we thought that our reasoning was pretty strong. As an attorney who's been practicing family law for 17 years, I thought this was one of the strongest cases for sole decision-making. But this judge disagreed, and she stated multiple times that she thought we were being unreasonable. And it would have been easy to push this issue to trial because my client really felt strongly, but he realized after listening to the judge kind of hammer us for probably 15 or 20 minutes about our unreasonableness, he realized that we were not going to get anywhere with her, especially if we went to trial. And we talked about it and decided that maybe it was better to give in on some of the requests or the demands that the judge was making in the hopes that we could salvage other parts of the case. So there, my client kind of saw where the judge was coming from, and he pivoted. He adapted his position so he could stay friends with the judge. So it's really hard to do this, I know, especially if you're passionate about what it is that you want. You're passionate about the reasons that you want what you want, especially if you think that the other side is an abusive parent or is neglectful or is somehow harming the children if there are children involved. But the main point that I'm trying to get across is that the judge is the decision maker in your case. The judge is really the main person who matters when you're going to trial, because the judge is going to tell you what you're going to do with your life. And if the judge is angry with you, and if the judge thinks you're not playing fair or not playing nice or not being reasonable, then the judge could, 1, not rule in your favor, 2, take it out on you in other areas, and 3, order you to pay the other side's attorney's fees. So, hopefully you gain something from this video. The message is really listen to the judge, listen to the messages that they're sending you, put yourself in the shoes of the judge, ask yourself, what would the judge do? WWJD, in deciding what positions you're going to take going into trial. This is Command the Courtroom. If you're watching this on YouTube, give me a thumbs up or a thumbs down, any kind of reaction. If you have any comments, let me know what they are. Also, like Command the Courtroom on Facebook. I post the videos there every week. Keep your questions coming, because those are the things that spur me to make videos every week. In the meantime, keep on trucking and remember to command the courtroom.